We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
Welcome back to Liberty Nation Radio here on the Radio America Network. I'm your host, Mark Angelides, still with you. And we are now delving into our special Talking Liberty segment with Liberty Nation's legal affairs editor, host of the excellent Uprising podcast, and a man who puts himself through Supreme Court arguments with more willingness than anyone I care to mention. Scott DeCrescenzo, welcome back to the show.
Thank you so much, Mark. My pleasure.
So, Scott, this week there was a very there are several cases in Supreme Court this week for oral arguments, but the one that I particularly want to talk about affects social media users and censorship. Now, surprisingly, this hasn't garnered a huge amount of national press, which surprises me because it is a First Amendment issue at heart, isn't it, Scott? Could you give us some details on it?
Well, this concerns the state laws that Texas and Florida passed to sort of in defense of conservatives, I think, for lack of a better way to put it, and to ensure that social media platforms didn't just willy-nilly discriminate against conservatives, deplatform them, cancel them, take their money if they were content producers without so much as a buy your leave. And there are sort of many different components within those two different bodies of state laws, neither of which are being enforced presently, both of which are held up while this case makes its way, these two cases rather, make their way through the Supreme Court. And one thing you did mention is they're being challenged by the social media giants. So NetChoice is the name of the group that they established in order to evade and escape liability. And I meant that without a value judgment, just a data point, and press their case in the sort of the public sphere for public policy. And that's the big people of the big companies, Facebook, Google, Yahoo, you name it, the who's who of the big tech world.
And so I guess at the heart of the issue is that you have two states, Texas and Florida, and they've put together some laws that have not yet taken effect because they're being held up by different courts. And now we're at the Supreme Court, so that we're expecting some kind of resolution soon. But by summer, let's by summer, June, I believe.
On it.
Yeah.
Yes. The end of June.
So, and I think that the question at the heart of it is, should these things be in the hands of the social media companies to determine what content is allowed on the platform, or should it be kicked back to a state level ruling on what can and can't be said on a public platform? And that really comes down to, are they publishers or the opposite of a publisher, essentially just somewhere where you can post something, right? Is that what it comes down to?
So there are a couple of distinctions that we can make that might be helpful for talking about it. One is a publisher, a publisher who is actually laying out the voice of what's been said. So, for instance, when Liberty Nation publishes something, we're the voice of what's being said. It may have an author's name attached to it, but we're also responsible for it in many, many ways, right? But if we go to the social media accounts that we maintain on Facebook, for instance, or on Twitter, those networks would not have those networks do not publish, strictly speaking, our messages in the legal sense. Now, literally, they're doing, they're making the ones and zeros happen, and it's their graphic interface that people are looking at when they see those words. But the words weren't put there by Mr. Musk or Mr. Zuckerberg. They were put there by the operators who have accounts there, right? Yeah. So that's what's more called a common carrier analysis. It's more like the telephone company rather than the newspaper. Yeah. That's helpful to think about. So one of the questions that the justices were wrestling with is whether these platforms are more like the newspaper or more like the phone company. Or, Mark, one of the other possibilities is maybe they're, the historical examples don't suit our current current needs. Maybe there needs to be a third way going forward. But
let me just delve in very quickly here, Scott, just to keep all the points in order. So the Supreme Court will determine whether they're acting, as say, in one of these three ways, as a publisher, as a carrier, or as something new that has yet been done. But if
They may determine them. During the
sure, they
oral
may.
argument, they were
Yeah,
discussing whether those classifications were present and how to use them to craft a ruling if they wanted to. One of the things we always have to worry about, or just not worry about it, but know it's going to happen, is they may not decide to rule on those bases at all, and
sure.
some other or third bases.
So if somebody determines that, for example, as you said at the beginning, this was really to brought up in Texas and Florida to essentially protect conservatives, but of course it protects everybody is the
Yes,
aim of the goal, the aim of the laws. But when a social media company censors a particular voice for viewpoint, or throttles their account, kicks them off, pulls their
right.
post, are they in fact in layman's terms, if not in a strict legal definition, are they in fact acting as a publisher by doing so?
Well, it seems like they are, Mark.
Right.
And I think that the Paul Clement is the name of the attorney that represented NetChoice and argued their case before the Supreme Court. I think what he would say is that they have a First Amendment right to curate their platforms.
Yeah.
That they are allowed to be pass-throughs of others' communication, meaning those of us who hold accounts on Twitter and Facebook, for instance, that but also they don't have to allow, for instance, the most graphic, disgusting imagery possible or words to that effect, that they can have content moderation standards and yet still enjoy the protection of Act 235 and the First Amendment, which gives them a shield from liability because they're not the author of the words that they're putting out there or the
The
images.
Act 235, is that of the Communications Act, is it?
Communi- the Communications Decency Act,
It's the
I
Act.
think, is the yeah.
So I guess that really puts from a liberty perspective, it's a conundrum, isn't it? Because many liberty-minded folks although users of these platforms, the idea that the platforms will have a control over what an individual might say is anathema. But by the same token, from the liberty perspective here, surely there's the argument of, well, this is my company and I'll do what the hell I want. You don't have to use it. That's your liberty, right?
Mark, I think those of us who celebrate liberty and want to continue to do so have to be mindful that what we want to have happen and what we would hope people would do
Mm.
don't have to comport to what we expect the law demands them of. And that the silos of civil society and what's resolved for the courts of law should be separate and distinct. And
Mm.
I don't want any social media platforms to discriminate against conservatives or libertarians or vaccine skeptics or whatever the latest what is it, malinformation, is that the term they invented to
Yeah,
describe
malinformation.
truthful information they prefer not be shared? In any
Yeah.
case,
There used
and
to
at
be a
the
name
same
for it. It's
time,
uncomfortable truths was what it
yeah,
used to be called. Yeah. Now it's
right.
malinformation.
And one of the only things I think I would detest more than that is the government saying you have to do X, Y, or Z
Mm.
or else. And that's we always have to remember, Mark, no matter what we're talking about, when the government says it, it's always suffixed with or else, or rather,
Yeah.
or else,
Yeah.
meaning they're going to take your money, they're going to take your liberty, they're going to do something to you that only the government can do because of its monopoly on force. And for me, that always controls in any kind of remotely close call. I think we just err on the side of letting voluntary interaction handle this.
Mm.
And plenty of companies, people thought they could never falter and never fall, and the people voted with their feet. So
Yeah, it's always important. I think it's always important to remind everybody that the First Amendment is there to constrain government. That's what it's
the
for, right?
justices struggled with this
Yeah.
during the oral argument. They were discussing whether or not does anybody get a First Amendment protection from a private company? It seemed unresolved, but I didn't hear anything from any of the advocates that would suggest yes was somehow grounded in our legal history.
I
So
suspect this is going to be one of those cases that gets cited again and again and again. But as Scott, as you always point out, any expectations from the Supreme Court, the only expectation to have is expect to be disappointed.
I was just going to say I expect them to sidestep the main issues involved because of procedural problems with this case, and I expect that it won't be cited very much because it'll just be shuffled aside, and they'll say we're going to wait until next year and deal with it then.
Always a possibility. We'll be right back with Scott DiCosenza after this short break. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
Don't get caught up in the media madness. Join our movement for free thinking and free speech at libertynation.com. Publishing news and analysis 24/7 with original articles by our team of authors who tell it like it is. Join us each week for online TV shows, The Uprising Podcast, and Liberty Nation Radio. We believe in free thinking and free speech. We are libertynation.com.